Hello, this is Neil Palacci, CEO of the Divorce Transition Professionals, and this is the first of many podcasts that we will be doing in 2025. I am happy to introduce to you today two of our incredible attorney members. Marshall Waller of the Westlake Village chapter, Westlake Village, California, and Ty Supancic of the Calabasas, California chapter. And they are here today to answer some questions for us with regard to the law, essentially, but specifically to get into some of the issues surrounding mediation and litigation. Obviously, there are some significant differences in those approaches. We'll also be talking a little bit about collaborative law, although we are going to focus mostly on the areas of mediation and litigation. Marshall Waller is the partner and founder of Feinberg Waller in Calabasas, California. They also have offices in Beverly Hills and in Westlake Village. And Ty Supancic is the owner, one of the founders of the Law Collaborative in the West Hills, California. I am going to get right into the questions because I know that our audience is very interested in knowing from you what exactly they can expect when going through a divorce. It's an extremely difficult time, and there are different issues to be dealt with. So I'm going to start with Ty, and we're going to get into the issue of mediation a little bit here. When somebody comes to you, Ty, and they're looking to do and go through a mediation process, can you explain to us a little bit about what you take them through and what the process will be? What should they expect?
So if I get called by one person, I tell them that what I've learned over the years is that if I spend any significant period of time speaking with them alone, excluding the other party is unlikely to feel safe with me as their neutral mediator. So rather than answer a bunch of questions and have a long conversation and get into details, I tell them, listen, I offer a free Zoom orientation where I meet with both you and your spouse at the same time. That starts you off on the same page. You both get the same information. You hear the same questions and the same answers. It's the most likely way to get through the process, starting off on the same page and staying on the same page. I don't charge anything for that. I answer all your questions. I walk you through the whole process. We discuss all of your options. We address all your concerns. And at the end of the meeting, people know generally, A, whether or not they're candidates for mediation, because many times they're not, and B, whether or not they want to work with me as their mediator. And then I ask them for a three-way email, copying their spouse with some dates and times when they're both free. That way I respond with a Zoom invitation directly to the other party who hasn't spoken to me yet. And then it's not like their spouse is forwarding a message from this guy they found. They see from the beginning that it's this, here's the Zoom invitation. And then I walk them through that process.
Got it. Very interesting. Okay, so in that situation, you've got to be very clear about the fact that you're not representing anybody, and you certainly want to remain neutral. So as we go over into the litigation side of the equation, Marshall, it's essentially the opposite. You are representing a particular person, so they call you, and what happens? What's your process?
Well, basically, we have a couple of options the way we handle it. We're kind of getting away from the traditional billable hour representation. It's been our experience over a lot of years that one of the biggest questions everybody always has, especially if they're going into litigation of any kind, is what's this going to cost? And unfortunately, we don't know. And any lawyer who says that they do know is lying to you. At the end of the day, it's going to cost a whole lot. And so what we do is normally the billable hour model, somebody says, okay, well, give me a $15,000, $25,000, whatever. Give me a big retainer. I'll work against it. You'll keep filling it up. And I guess when we're all done, we'll see how much it ended up costing. And what we're trying to do is, and we still do that, by the way. If somebody wants to come in and have a meeting with me, Happy to do it. We charge for our consultation. I actually tried doing it for free, and I literally found I was spending 4 or 5 hours a day, every day, giving legal advice out to people for free. And so that ended up creating a huge problem, as you might imagine. But people come in, and if they want to spend about an hour with me, we get a basic sense of what's going on with their case. I can, kind of give them a ballpark of where their support is probably going to end up. I can answer their questions about what happens and things like that. Another thing that we do is we now do, we call them a matter analysis. And the cost varies, but it's around $1,500 to $2,000. It's 2 or 3 hours with me. It's a very detailed evaluation of your case, an examination of the facts, development of a game plan, calculating child support, spousal support, the steps that are needed to go forward, and the costs associated with those steps, because we're going to a fixed fee model in that context. Somebody comes in, they say, all I want to do is get a petition on file. I can say, okay, that'll cost you, $700, period, the end. If it ends up taking me 10 hours, well, that's on me. And so what happens is the risk of the divorce costing more than you think it was going to cost is now on the lawyer instead of on the client. And that's actually a pretty well-received concept. It doesn't really make it less expensive. It just makes it more predictable. And so basically I do what Ty does, only I just do it with one person. And I get a sense of where they're at. I give them a whole lot of advice. And if it sounds like their case is something they can work out without spending a lot of money on lawyers, I will suggest that they talk to a mediator or a collaborative attorney, because they'll save a whole bunch of money doing it that way.
So that leads me to the next question. Sometimes people come to you. You've both said the same thing, in that the client that you, or I should say the prospective client that you speak with, isn't always going to hire you. They say, oh, mediation isn't for me, or litigation isn't for me. It can work either way. I would also imagine that there are some situations where mediation is used and then it goes to litigation because it's not working for whatever reason, and maybe the other way around. Maybe in litigation, mediators are also brought into that equation. So how does that, and why does that happen? Like, you do your best, obviously, to make sure that mediation is going to work as you're going through the interview process, but sometimes you get to a point where it isn't, and it's not you, it's just the couple, I assume. What's going on there? How does that work?
Sometimes people, in every divorce case, once you file and serve a petition, there are automatic temporary restraining orders that restrict the conduct of the parties. It keeps them from taking the kids out of state, renewing passports. It keeps them from changing any kind of insurance coverage. It keeps them from moving money around. There's automatic temporary restraining orders that are served in every case. And what often happens, not often, but when they fall out of mediation, it's generally because somebody did something stupid. They went out and bought something unexpected for an amount of money that is shocking to the other party, or they, in a fit of anger, canceled the other party's insurance, or they took a bunch of money out of a joint account, and the other party panics, they get scared, they don't feel safe, and they call a litigator. That's one of the scenarios. I tell all my clients, don't date during this process. Oh, the other party doesn't care. Okay, don't date during this process. Doesn't matter whether you think they care or not, because that's another thing that will set people off. The process will be going along really well, everything's going great, and then someone sees something on social media and they think, oh, they're stepping out now, and we're not even divorced, and everything goes sideways. And it's hard to bring it back when it's an emotional issue like that.
Yeah, I've certainly heard situations where people will say things like, well, it's amicable, we're getting along, everything's going fine. I don't care if she does this or that or the other, until they do.
Yeah.
And then it goes sideways. Yeah, of course. So, and then on the litigation side, Marshall, you've got people that are litigating, and then you can also bring in a mediator, or sometimes you refer it out to mediators, or would you do that up front before it would get into the litigation process?
I usually do that up front. If I think that they have a case, like let's say they really are getting along well, and they don't have this huge complicated case. Even if they do have a huge complicated case, if somebody comes into me and says, I was talking to my wife and everything is fine, we agree on everything, we just need somebody to put the paperwork together. Usually what I'll say is, you might want to speak to a mediation attorney. You should have an attorney in addition to the mediation attorney that you can run questions by, because the mediator can't give legal advice to anybody. But I will say it's going to be a lot less expensive if you do that way, because typically, and Ty, correct me if I'm wrong, but what a lot of mediators do is they create the agreement and then they start the legal process, the required documents that you have to file to get everything going and official. That way, they're not going to back out of their agreement. And if you start with the litigation and you check the box that says, I want spousal support, for example, that might be enough to just set the other side off and say, oh, well, I guess it's on. Now we're going to fight. Even though they didn't really want it, but the lawyer said, oh, yeah, we should ask for this. And so it's rare that I see a case where we're in the thick of the litigation and I say, let's go to mediation. However, what we will do is once we've done all of the due diligence and the discovery and obtained all the information, I will then typically say, now is a good time to take this process to a neutral third party who can hear what everybody has to say and bring them together in agreement, because the litigating lawyers are not in that place. They're in the, I'm representing my client's interests, and I don't care about the other side's interests, or vice versa. And so that's why you want to get in front of a neutral who can say to, for example, let's say my client is taking an unreasonable position and I've tried to talk them out of it. The mediator might look at them and say, this is a bad thing you're doing here. You should listen to your lawyer. And sometimes they just need to hear that from somebody who doesn't have a dog in the fight.
Right.
That's a great point. And I've had cases where I met with them to mediate, and they said, we're going to, that sounds great, thank you. We're going to get ourselves started, and we'll come back when we're ready for you. And then I'll get a call 6-9 months later, and the person met with you. I did something stupid. They freaked out. We're $60,000 into legal fees. I don't know how to make it stop. Okay. You could invite them back to mediation, and if they want to, they can tell their litigating attorney, I want to put everything on hold. We want to meet with the media, but they have to agree. It's a consensual process. Both sides have to want to do it. And Marshall, you talked about getting the agreement first sometimes, and then filing paperwork. That there are mediators that do that. Once I'm hired, I have a checklist of issues that we go through with both clients. And we talk about everything that could possibly come up in a divorce. And one of those issues is, when do you want to file? Where do you want to file? Who's going to be the petitioner? Who's going to be the respondent? And sometimes there's a compelling reason to file right away because they want to start that 6-month clock ticking, or one of them wants to buy another home and they need to be getting 6 months worth of spousal support pursuant to court order before they can apply for a mortgage. And so we file paperwork early so we can get a stipulation in place so that they can make that home purchase. Sometimes it's too scary, and so they want to see what the settlement's going to look like before they file any paperwork, and that can work. But when they do decide that they want to do the petition and the response, I fill them out for both parties. I fill them out completely bland and milquetoast. There's nothing inflammatory on there except the pre-printed language that says you're being sued, which I can't change right now. In January of next year, we'll have new joint petitioner paperwork for couples that want to file as joint petitioners, but still in California for at least another year. One party has to petition and the other party has to get sued and become the respondent. But before we file or sign that paperwork, I review it with them both together. We read through it all. They see what it says. It ends up being a non-issue. It ends up not being upsetting at all. And then when I file the paperwork and serve them by mail, they've already seen the paperwork. They don't care. It's really a non-event at this point.
Well, and I'm sure you explained to the clients that with the exception of opening the door to the courthouse, it doesn't mean anything. They're just position papers. It's like nothing. It's just you have to do it to get inside.
Exactly.
That's right. Exactly. Well, hopefully that doesn't become an issue. And when they're working with you, and I know that I've had this with clients that I've worked with, and they end up with the MSA at the end, and here's the agreement and so forth. Do you, Ty, send them or suggest at least that they each go and hire an attorney to review the agreement? Not that they always do, but
Multiple times in writing. Everything I have my clients do comes along with written instructions, because some clients are great about reading them. And if they read the instructions, they save money. Some clients want it explained to them. That's fine too, but they all get written instructions. And in those instructions are admonitions that they need to seek legal advice. I'm not advising them on the completeness of their disclosures or the completeness of the other party's financial disclosures. I'm not a forensic accountant. I'm not giving legal advice. I'm not giving tax advice. And the final letter that they get when they finally get the marital settlement agreement and judgment papers to review says, and if you have been putting off hiring an attorney until now and you don't have one, now would be a great time to do it. If you'd like a list of mediation-friendly attorneys, I'm happy to provide you with some names. And what I see in my own practice is by the end of the mediation process, most people are so comfortable that they don't want to spend the money on a reviewing lawyer. But there are multiple writings where they say they knew they had a right, they had plenty of time, they had money, and it says it in the judgment also. I had plenty of time to hire a lawyer, I had the resources to hire a lawyer, and whether I did or not.
Yeah, that's their decision at that point. So, Marshall, when we go back to the issue of litigation, I mean, as you had said before, each of the attorneys, you representing one spouse, another attorney representing another spouse, and they're both working very hard to make sure that they're doing what's in the best interest of their respective clients. And then the two of you, the two lawyers, are quote unquote negotiating. You're talking, you're sending each other letters and so on and so forth. There are hearings, etc. But how many of the divorces actually end up going to trial?
About 5%.
About 5%.
And that's
because
mostly it's due to the very high cost of going to trial. Litigation, it has been said that litigation is the sport of kings. It's extremely expensive. Interestingly enough, we are mandated by the family code to work together, not so much as an adversary. This is an adversarial system that we're in, but we're really mandated to work together to resolve the problem. And unfortunately, because we are an adversarial system and the lawyers are trained that way and they're used to being that way, it's, give me my sword and shield and let me do battle. But we're not really supposed to do battle. We should be able to reach out to the opposing attorney and say, hey, can you send me this stuff? And they do. We send discovery out, formal discovery. But if you read the cases and you read the statutes, we shouldn't ever have to do that. The spouses have an absolute fiduciary obligation to voluntarily and transparently exchange this information, and yet millions of dollars per month probably are spent on discovery battles because the attorneys don't want to give that up. I don't do that. I approach every case. Hi, I'm here. Let's help get these people through this problem so we don't, it is said the clients can either put their children through college or they can put the lawyer's children through college. And so we kind of want to save them as much money as they can. And the reason that a lot of these things don't go to trial is, well, I would say 80% of the cases settle, 20% of the cases they want to go to trial, but those 15%, they can't afford it. So they kind of end up settling, but they begrudge it. They hate every minute of it.
Right. And I mean, I know I've had conversations with you both about this type of thing, but at the end of the day, you really don't want a stranger sitting on a bench in a black robe making all these life-changing decisions for you, even though you think you may want them. I mean, you're sitting, let's get the guy. He's a son of a gun or whatever, But at the end of the day, that fellow doesn't know you from Adam, and yet is making decisions about you that are going to potentially change your life permanently, right?
There's a very well-known child custody evaluation expert, mental health professional by the name of Ian Russ. And he created his pyramid of understanding. And on the bottom of the pyramid, that's where the family is, the cousins, the extended family, the friends, the neighbors, all right? You go
Right.
up a level, all right? Here's where the lawyers are, the doctors, the clergy people. And up here, that's where the judge. And the lines indicate the amount of information we have to solve the problem. And the person with the least amount of information and knowledge is the judge. So technically, in our system, that's the last person who should be making these decisions.
Yeah, exactly. Well, I guess it's just as well then that only 5% of the cases get to that point. No, I suppose that's good news. Even though 15% of that last 20% want to, it's just as well that they can't afford it because they're better off making the decision themselves along with their attorneys, correct?
But what happens when they're conflicted is 100% go to court and ask for decisions on a temporary interim basis. I want support. I want fees. I want to use the car. I want to use the business. I need access to this account. I want custody. You don't get custody, and all of these little things. Every time you go running into court, you're going to spend $5,000 or $10,000. And I had a client once tell me that she wanted me to file an ex parte court request because she did not want her husband feeding their child grilled cheese sandwiches.
Oh my goodness.
And I said, well, I'm not going to do that. And she said, well, I'll just go find some attorney who will. And I said, well, be prepared to pay about $10,000 for that. And so then suddenly grilled cheese wasn't so bad. So, we're not catching them at their best. We're really not.
Right. I know.
They're making their decisions from an emotional place, and they rely upon us to be the objective people, to not be emotional. And unfortunately, our business, our industry is plagued with attorneys who are dramatically emotional and who just immediately jump into the skin of their clients, and they are just as emotionally impacted as the clients are. And that's where the cases become truly dramatically expensive.
The family law bar seems to attract that kind of lawyer.
Yeah, it does. I think that what happens is we're all type A personalities. That's why we became lawyers to begin with. And the people that want to become family lawyers, they're either working through some trauma that they went through in their own life, or they want to help people and they decide, I have to help, and this is what I have to do to help. And yeah, we all want to help them, but we don't want to destroy relationships. There was I won't say his name because everybody knows who it is. He has since passed away, but there was a very well-known attorney in Los Angeles who many years ago used to say, this is like 30 years ago, give me $100,000 and I'll give you custody of your child. You'll never speak to the other parent, but I'll get you custody of your child. And that's really not the best way to do it, in my opinion.
Yeah, at the end of the day, the, if you will, best divorce scenarios are the ones where, yes, there's a divorce, the kids are okay, and everybody grows up relatively happy, and then the families are actually together. They can actually sit around the Thanksgiving table, Christmas dinner, whatever it may be, and not rip each other's throats out. They don't have to be best friends, but they can all get along. I've seen some really good situations where the spouses have gotten remarried and everybody's friends, and they still sit at the Christmas table and Thanksgiving table with their new spouses and sometimes their new children. They have, second families and so forth. And that's a wonderful thing to see. If you can get to that point, I'd say that is, that's a very, very good thing. I want to just ask a question going back to the issue of going to court and having a trial, because I think sometimes people get confused with the idea of having a trial, which is when all the decisions are made and the final decisions are made, versus having a hearing about a specific issue. So it doesn't necessarily mean that as you're going through the court process, the litigation process, that you won't go to court. You could go for a hearing on an issue. So what's the difference there between the hearing and the trial?
Generally speaking, a hearing, the court does not receive evidence at the hearing. They've got all the paperwork. They've read what everybody writes. They might ask a question or two if everybody's there. They don't have to. And then they make a ruling. And typically, hearings are how they handle the interim things, because you start your case and then you have a trial or a settlement. And during this period of time, issues may arise that need to be addressed. Like, I need exclusive use of the car. I need exclusive use of the house. I need to get into the bank account. I need custody of the kids, or whatever. And so you have to go to court. If you can't agree, you have to go to court on all these things. And you have to ask the judge, we can't make this decision. Will you please make it for us? And the judge will do that in the context of a hearing. Sometimes in the context of a hearing, you can ask for an evidentiary hearing. And you tell the judge, hey, this is a lot more complicated. You're not going to be able to deal with it in 20 minutes. We're going to need like a half a day, because we're going to need you to hear testimony from certain people. That's an evidentiary hearing, which for all practical purposes is the same as a trial. A trial, the concept of a trial as that word is used, has legal effect, all right, which is completely irrelevant to the parties. They don't care. But when you can only have one trial, and the trial resolves the remaining issues in the case, and it produces a judgment. A hearing produces an order. And typically those orders in family law, they're temporary. And so the issues are revisited at the trial. So you go in for a temporary custody order and you get it, and you think, I'm home free. No, you're not, because at some point we can go to trial and those issues will come up again. And it gets kind of complicated at this point, but there are legal distinctions, but the clients don't care. From the standpoint of what's going to happen to me, an evidentiary hearing, you may be giving testimony, you may be questioned, and a trial, you definitely will be.
Got it. And Ty, when you're in mediation, I mean, we've talked about the fact that you don't go to court anymore, and you do the mediation work. A lot of what you're doing is on Zoom and in person, and I understand that. And you're doing the collaborative law work, and that's generally done in a room with other professionals and so on and so forth. But even in the mediation, well, let's stick with mediation for the moment. There's going to be disagreement. There's still all the paperwork that needs to be filed. I mean, all the paperwork is the same. That still needs to be filed. So other than the fact that you're not actually going to court to have hearings and trials and so forth, are there any other differences in the actual divorce process between what you might do and what Marshall might do?
Differences in what I do, the clients make all the decisions. They determine the outcome between the two of them. And if there's an issue on which they can't reach an agreement, you can bring in a subject matter neutral. For instance, if there's a complex business issue or valuation issue, you can bring a joint neutral that has a fiduciary duty to both parties that is going to render an opinion that the parties can adopt or accept. Our recently retired supervising judge said that he believed that at any given day in Los Angeles County, 85 to 90% of all the hearings were people coming back to try to change something a judge had done earlier because they didn't like the outcome. And that doesn't happen in mediation because they agree on the outcome. They determine what those terms are going to be. And so you generally get much more durable results. How is it otherwise different? In litigation, you can agree to a joint neutral expert. People often don't. One side wants this expert, the other side wants this expert. Then you get dueling experts, and the judge makes a decision based on those two opinions. But well, when I was litigating, when my father was litigating, we would often have a contentious issue, sometimes over parenting, and we would agree on a joint parenting plan coordinator that both attorneys liked, and that person would come in and. Now, you could always reject it if you like, if you haven't signed a stipulation saying it's going to be a binding outcome. But the biggest difference between the two outcomes is, as Marshall said, that stranger in the black robe with the least information is making the decisions in litigation, and in mediation and collaborative law, the parties are reaching agreement together, knowing their family and what's best for their family.
And I recently was quote unquote involved in a case where the husband and wife were mediating, and I was working with the wife, and then they would come out of mediation, and the wife and I would then talk, okay, well, it looks like this has been decided, this has been agreed upon, blah, blah, blah. And then a couple of days later, she might call me. She did call me a couple of different times, and the husband said, oh, I'm really not happy with that. Actually, I'm changing my mind, blah, 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 blah. And then she would get all flustered and say, oh, I guess we're going to end up in court. Mediation isn't going to work. Then they'd go back into mediation, and he will have calmed down at that point. Oh, I thought about it, and, I was just in a bad mood that day or whatever. There seems to, so at what point, that leads me to a question, which is, at what point, Ty, do you say, guys, I don't know what to tell you. We can't seem to come to an agreement on 5 out of 10 of the main issues. I guess you're going to have to go hire a lawyer and figure this thing out. When does that happen?
I haven't had that happen in recent memory. I had a couple who were mediating okay, highly emotional, lots and lots of conflict. One of them did something that scared the other. The other one said, I can't be in the same Zoom room anymore. I want to do shuttled mediation. You meet just with me, and then you'll meet just with them, and then you'll meet just. And I said, okay, that's less efficient, but we can do it that way. We did it that way for a little while. The other party did something, again, stupid, that fell apart. The party who had asked for the shuttle mediation said, it's over, I'm hiring a lawyer. I said, I'm sorry it's come to that. Would you like me to write up a deal memo of your agreements that you've reached so far, so you don't have to relitigate those with your lawyers? If you're both still in agreement, it's not binding, but at least you can show your lawyer, this is what we've agreed on, here's where we don't reach an agreement. And they both said, yes, please prepare that document for our lawyers. And I did. And I sent it to them with an email that said, look, here's all the stuff you agree on. We only are apart on this one and this one. And the difference in this one almost erases the difference in this one. You think that you need your lawyers to do this, or is this something? We settled the whole thing by email. It took another 2 weeks. And they both ended up having their lawyers review the outcome because there was still fear on one side, but it's still settled because it's not my responsibility to have them reach an agreement. My responsibility is to give them the space to reach an agreement and facilitate the conversation necessary. But I'm pretty good at vetting my clients, and when I suspect it's going to be a problem, I don't take them on because I don't want someone out there saying, I tried mediation, it didn't work.
Right.
And there are a lot of people who've tried it and it didn't work. But that's a lot of times mediators who are also litigating, which I used to do, and I know that I was too aggressive and combative in my mediation. And I know it wasn't, and that's one of the reasons I gave up litigation, was because my mediation clients weren't getting someone who was calm enough and patient enough. And neither was my wife, which is the main reason I gave up litigation. Like, I can't separate this. I come home and I'm combative and I'm argumentative. It's like, no, I'm just going to mediate. But really don't have them fall out.
Gotcha. I ask people, when they ask about mediation, I say, I have 2 questions for you. Okay. Do you understand the meaning of the word compromise? Oh, yeah. Okay. Does your spouse? And if they say yes, I say, you guys should mediate. And unfortunately, an awful lot of people think hiring a mediator is let's retain this person. Let me hire Ty so that he and I can talk you into giving me what I want.
Right. Yes, exactly.
That's not, obviously, that's not how it works. And they get very
Yeah.
disappointed when they learn that. And those are the ones who say, oh, mediation doesn't work. But
Right.
you can usually spot those people pretty easy on, pretty early on.
So let's get into some of the specific issues that people ask about money, because at the end of the day, that's often what it comes down to, right? Money and kids, money and custody. So people in California, I know this is not necessarily true everywhere, but people in California and many other states where there is community property laws, and they have the knowledge of, well, everything gets split 50-50, right? And then people will say, yeah, but I have a friend whose spouse screwed them and they got nothing, or they got 10%. I mean, literally, I don't know if that's true or it's not true, but you've heard people say it. I've heard people say it. But the idea is that you're supposed to get 50% of everything, but there are exceptions, inheritances and property that was around pre-marriage and, stuff like that. So what has been your experience, Marshall? I'll start with you with regard to the asset split issue and what people think they're going to get versus what they do get and what they think they're deserving of, and all that stuff.
I'm always amazed at how little the general public knows about how their property in California gets divided. It starts out as 50-50, and it is 50-50. Nobody gets screwed. When somebody says, oh, I got a divorce, I got screwed. No, you didn't. No, you didn't. You didn't get what you thought you were going to get, but you did not get screwed. The law is not set up for that. It's not. And I've had people say, well, my friend says XYZ. And I always say, well, let's get your friend on the phone. Let's talk to him. Let's find out what really happened. So really, people come to a divorce with an idea that, well, I'm the one working, so I earned the money, it's all mine. Or what do you mean I have to give her or him part of my retirement? That's not fair. And I tell them, well, it may not seem fair to you, but it does to the legislature of the state of California. And so add on top of that the fact that family law is really genuinely extremely complicated, way more complicated than people think, way more. We have to understand tax law, tort law, contract law, real estate law, psychology. It just goes on and on and on. And there are a lot of things that impact who gets what in a divorce. But as I like to say, if you think about it and if you are open-minded, it's all pretty easy to figure out. It's all kind of common sense stuff, but nobody knows about it. And then finally, add to that, there are a handful of things that nobody knows. Most lawyers don't know if they don't practice in this area. And in those instances, you're going to get the short end of the stick because that's how the law works. And if you knew about it before you did the act that resulted in that, you wouldn't have done it, but nobody knows about it. And so there's nothing anybody can do about that. It's just, sometimes there are these weird laws that you don't understand where they came from or why, they just are. And once the die has been cast, you just have to roll with it.
So just to play devil's advocate a little bit, when you've got these situations where, and I understand it's all talk, and I don't know any more about the truth when somebody's telling me about something than anybody else. I wasn't there, so I don't know. And for me, I'm only working with one spouse. They could be telling me, I don't know, it could be completely truthful or completely not, or somewhere in the middle, which is usually how it is, right? But you do hear occasionally about somebody who's saying that the spouse lied about everything, that he hid everything, that it was in the brother-in-law's name, and it was I said I was drinking, and I mean all this stuff. People do lie, right? I know it's hard to believe. People lie. So what?
It used to be hard to believe, not anymore.
Not anymore. No, I know. I mean, it's so this is the and I get people that call me, oh, my husband, he's very powerful, blah, blah. Sometimes they'll say he is an attorney, or his best friend is, or he's got all the money. He's got access to all the money. And so he's going to bring in this shark, and I'm going to end up with nothing. And I know at the end of the day, you're saying that, it doesn't work out that way, but yet you hear these stories. So what is that?
That
Out
usually,
that way, Neil. If someone rolls over and doesn't stand up for themselves and doesn't ask the court for what is it they're entitled to, they will get screwed. It can happen, but it's because they didn't see it through. It's because they didn't hire a lawyer to advocate for them or defend them. It's because
yeah.
they didn't prosecute
So
their
if you've got a
case.
situation, I'll just take this one more step and then we'll move on to something else. But if you have a situation where there is essential control, I'm going to use the traditional roles. The fellow has a business, he has the money, he doesn't tell her about anything, blah, blah, blah. He has the access, he has the passwords on the internet, everything, right? And he goes out and plonks down 20 grand for a retainer. She does not have the money to do that, doesn't have access to money to do that. How does she then do that?
She does one of two things. She goes to family and friends and asks them to loan them the money, or she finds an attorney who will go into court for her for free to see if they get the money, which is not very easy to find. Or she'll borrow the money. She'll find a way to put together the money to retain an attorney to go to court and ask the court to order, in your instance, the man, to contribute to her fees because he's the one that makes all the money. And there is a broad range of law in California associated with that concept. They don't necessarily, a lot of people come in here and say, well, my husband has to pay all the fees, right? No, but if your husband's the one that's got all the money, we can certainly ask for a contribution, and usually the court will go along with that and they will grant it. I worked on a case a while ago where we went into court and the court gave us $650,000 in fees advance because the case was huge and this person was a billionaire and the wife didn't have access to anything.
Wow.
And so that's how they settled it.
Yeah.
They didn't settle it. That's how they addressed it. And so there's a mechanism. And even if you have to go in by yourself and you have to say, hey, I can't afford to hire an attorney to even give me advice on this. And my husband works for, Amgen and makes $1 million a year. And, can I please have $10,000 so I can go get an attorney? The court's going to give it to you. They're going to say, yes, you pay her 10 grand, go do it. Most attorneys, in my opinion, good attorneys who are familiar with this, if I have a case with a very wealthy opposing party and I know the other attorney, I'll just call them. I'll say, hey, I need some money. Give me some money. And they will, because they know, they don't want to spend 10 grand going into court. They know they're going to have to give money anyway. I certainly do that. I get calls, hey, I'm representing, your client's wife or your client's husband. We need some money. Okay, how much do you need? All right, great. We'll send it out. Now, in your average mom and pop case, you got wage earners. They're not making that much money. They have a little bit of money in the bank, but they don't have access to it. You have to be careful how you spend your money. People say to me, well, what am I supposed to do? I've got a trial coming up and I don't have money for an attorney. What am I supposed to do? And I always say, go in on your own and tell the court your story. And if they won't order money, at least explain your situation as best as you can. The court is under a mandate, essentially, to do right by the parties. The court's duty is to marshal the community estate and then divide it equitably, period. And so if you don't have a lawyer, go in and say, wait a minute, Your Honor, what he just said, that's not true. We spent this, we had this, we did that. And the court is required to obtain as much information as they can. Lawyers make it easier. All right, we make it easier. But 80% of the cases in Los Angeles County are heard without lawyers. And Los Angeles County is the divorce court, is the biggest, the busiest court in the world. LA County.
Wow. Wow. Yeah, that's incredible. So when we get into, we've talked a little bit about the assets, and as I had mentioned, you split the assets 50-50 typically. Inheritances and some other issues can make the split a little different, separately owned property and so on and so forth. And then you get into the income issue, spousal support and child support. And I think at different times I've had discussions with each of you about the use of the DISO master, which is kind of the standard in the family law. It's not the standard. Well, it seems to be the standard piece of software anyway.
It was the standard.
It was. Yeah,
it was
it's gone
the standard.
now.
Okay, well, this will be interesting to know the differences. And some of the discussions that we've had is that when the DISO master is used, that it is I don't know if the word's accurate, but it is used kind of verbatim for child support, but for spousal support, it's used more for temporary spousal support purposes. So talk a little bit about that. Go ahead, Ty.
Let me talk about mediation. In mediation, the parties are supposed to know what DISO master says, and they have a right to agree to whatever they believe is in the best interest of the children. And in my cases, my clients often agree on child support that bears little relationship to what DISO master says, because they know their kids' needs, they know their kids' interests. They will make agreements sometimes that involve support after the age of 18. Sometimes they make agreements about college. They'll horse trade and horse swap, and so they need to know what it is, so they're making an informed decision. But they very often in mediation reach a completely different agreement with regards to child support. And Marshall, you take it from there.
Yeah, child support is the court mandates, the law mandates that you're entitled to a guideline amount of child support. And what's happening with DISO Master is the publisher has just decided they're not going to support it anymore. And so pretty much everybody in Southern California is switching to a computer program called X-Spouse, which is really the same thing. It works the same way, it looks the same way, it's fundamentally the same thing. And that program will take the formula, the algebraic formula that's in the code as to how you calculate child support, and apply the numbers that you put in it and come up with a number, and that's your number, period, the end. That's going to stay the same. Spousal support, you are correct. There are about 14 factors in the code for the determination of permanent, and permanent's kind of a misnomer, but long-term spousal support that happens at the trial or upon settlement. And those factors include the age of the parties, the health of the parties, has there been any domestic violence, did anybody give up a career, marital standard of living, how much do they all make, stuff like that. And the court, the legislature requires an analysis of all of these factors before a determination as to how much money should be paid. Temporary sport's different, so it's just a formula. It's a straight, flat formula. A computer can calculate that, and that's what DISO Master does. With regard to spousal support, the parties can agree on anything they want. Anything. Child support, they can't. It is what it is. And I mean, look, they can agree that we both make about the same amount of money. We both have the kids about the same amount of time. We're not going to have, we don't need a child support award at this time. They can agree to that. And I would say 99 times out of 100, courts are going to be, they're fine with it. They don't care. But at any time, one of those people can go into court and say, I want an order. So they can agree, but it's a little tenuous. Spousal support, you can do anything you want. You can front load it, you can buy them out, you can step it down, step it up, waive it. You can do anything you want. They don't care about that. But as far as the determination, if you leave it up to somebody else to calculate, there are factors that need to be considered. And it has been my experience that judges, being human beings, will typically take the temporary support amount, which they can calculate, and they'll kind of work around that to then go through the factors and try to end up in a similar ballpark.
Gotcha. Yeah, I find that the spousal support and child support is all very interesting because people have certain expectations. I mean, again, when I'm working with my clients, I sometimes they'll say, well, my understanding is that I've been married for 22 years, therefore I have a long-term marriage. It's longer than 10 years, and I'm going to be getting lifetime support, right? Well, Ty, is that right?
If you agree to it, but lifetime support, what the permanent order that Marshall was talking about being a misnomer, it's the order afterwards. And courts, if the parties don't agree to something else, the courts in a marriage that's 22 years long are going to maintain permanent jurisdiction over the issue of support. And the court may in the future determine upon the application of a party that it's no longer needed or it needs to be adjusted, but they're going to maintain jurisdiction over it typically. But in mediation, people agree to anything. And like Marshall said, very often it's going to be front loaded or a buyout, or it's going to be something that they like, that they've got some more security around, rather than this sword of Damocles hanging over them that it could change for either party, the payor or the payee. People dislike the idea that something can change, and they like to negotiate something that they understand and can count on very often.
An interesting aspect of that, and I use the example that the door to the courthouse is open to come in and ask for spousal support, and the court does not have the power to close it and lock it. They can't do it, except with a marriage of 10 years or less. With those marriages, they can. They can say, this is how much you get, and that's it, period, the end. But if you've been married more than 10 years, the door stays open. And that's what this whole thing about the 10 years, I got to be married 10 years.
Right.
You don't automatically get temporary, you have permanent support. It doesn't mean anything except what I just said. And the amount of support, the length of time, it's mandated to be the period of time required. It's for a reasonable person to become self-supporting, which the legislature has decided is roughly, in marriages of 10 years or less, half the length of the marriage. So if you've been married for 6 years, you can count on getting support for 3, 8 years, 4, stuff like that. The court has discretion, but that's pretty much how they do it. Anything over 10 years, the court could say, I'm not going to award any spousal support, period, the end. I know you've been married for 35 years, but no, not going to do it. I don't think it's required. So 0, but they can't lock the door. So 5 years later, if God forbid something happens and they need support, they can come in and they can ask for it. Interestingly, it's not that easy because the person asking has to show a significant change in circumstances, and the passage of time doesn't count. And sometimes somebody says, we've got a marital couple and one party works and they're making $100,000 a year. And support is set at $500 a month, let's just say. And they've been married forever. And 5 years post-separation, the guy that's paying the support wins the lottery and is now worth $10 million. And so the spouse goes in and says, I want more money now, because he's making more money. He has more money. Well, guess what? You're going to have a cap based upon the marital standard of living, which is a function of $100,000 a year. So just because that person won the lottery doesn't mean you get more money. However, if you have children and that person is paying child support, the child is allowed to participate in the future post-divorce benefits, financial benefits that the paying party experiences, even if it means that the ex-wife, gets to live better too. So that's kind of it.
Oh, that's interesting. Now, even in a marriage, and correct me if I'm wrong, but even in a marriage that is longer than 10 years, where spousal support will typically be paid, if the payor and the recipient agree that there's going to be a buyout, that would be permanent, right? Even in that situation.
They can agree on anything they want.
No, right. But if somebody says, well, I'm going to pay you $500,000 in lieu of the $5,000 a month I was going to pay, you can't go back and change that, right? Is that not permanent at that point?
So long as it's
people I've seen people do their own divorces
Yeah.
with a buyout without terminating the court's jurisdiction, and they screwed up because they left it open. If you were going to negotiate a buyout, you want to terminate the court's jurisdiction. You want to close that door to the courthouse, as Marshall described.
And you still have to close the door. It's not closed
Otherwise,
as
it's
a
not
result
really a
of
buyout.
agreeing. Right. I
Right.
see. Oh, very interesting.
And it has to be unambiguously closed.
Yeah, exactly.
Which means, in
mean,
lawyer speak, 3 or 4 paragraphs repeating how nobody can go back.
right, in bold print, underlined, and all that good stuff. Yeah. And of course, you know, there must not be any kind of fraud, and there must not be any kind of undue influence. I'm not sure if that's the legal term, but you know, there are some exceptions where you can go back and you know, say that you were, you know, drugged or whatever, God forbid, whatever situation brought you to that decision when you would normally not have made that decision, let's say. Although you would have to go back and deal with that through the legal system, nevertheless, right? I mean, you would hire a lawyer to prove that, or to try to prove that. You may or may not have the money to do that either. So those situations,
it's pretty
I'm sure,
hard typically to prove undue influence or duress. Because typically every judgment's going to say, I signed, there's no undue influence, there's no duress. And I mean, unless you really had a scenario where someone was in opposing counsel's office without their lawyer, you know, it's pretty hard to prove duress and undue influence.
Yeah,
there's also statutes and limitations. You have to make those claims within a certain period of time or you lose them.
Yeah.
That makes sense also. Well, this has been terrific. Believe it or not, we've been going at it almost an hour, and I really, really appreciate the time that you both have spent. And I know that there are 100 other questions and 100 other situations, and we could probably go and continue to talk about this for many hours to come. But that's exactly why they need to contact you and chat with you individually and get into their own situations. And if you have questions for either of these two gentlemen, I'm going to allow them right now to provide you with their contact information. We will also be available, of course, I'll give you my contact information. If you want to reach them through me, you can do that. So Ty, would you please give everybody your name, your email address, and your best phone number that you would like to be contacted?
Sure. Thank you, Neil. Ty Supancic, Ty at thelawcollaborative.com, 818-348-6700.
Excellent. Thank you. And Marshall, please.
You can reach me. The best way to reach me, the easiest, is to go to feinbergwaller.com, FeinbergWaller.com, or just Google my name, Marshall Waller, and it'll come up, and you'll see there's all kinds of invitations to schedule appointments, reach out, contact us. My email address is there, phone number's there.
All right, terrific. And if you need to contact me, Neil Palachi, you can do so at neil@thewealthcreatorcompany.com or 818-606-7327. And Marshall is absolutely correct in saying that all three of us can be found by being Googled using our names, and everything will come up. Or you can even go to ChatGTP and just ask for one of us, and that nice virtual person will tell you exactly how to reach us. So thank you all for listening in. We look forward to being in contact with you when and if you need our help. It's been a pleasure. This is Neil Palachi, CEO of the Divorce Transition Professionals. Thank you again to our guests, Ty Supancic and Marshall Waller. We appreciate your time. Take care, everybody.
Thank you, Neil. Thank you, Ty.